So I'll do introduction. Then we go to the business of the day. This is Professional
Yes.
Ethics, April 2022. Professional Ethics. These are online classes ahead of April 2024 exams. Professional Ethics was the most failed subject arising from November 2024 exams. And I thought that I could create content that is in my website, by exam preparation website. Yeah. So in the website, there is year 2008, 2019, question and answer 500, all questions combined for all those like 12 years. Then is the June 2021. There's November 2021 also. That is a recording that we have done. Yeah, it will be I will upload it in the website soon. Now we are in April 2022. So to pass this exam, this is called Professional Ethics and Practice. It is a subject that deals with the ethical conduct of an advocate. So for you to pass this subject, I usually insist it is divided in three parts. There is the provisions of before you enter as an advocate, become an advocate. That is advocate training program. So most like 10% of the question will come there. From there, you needs to know the Kenya School of Law Act and Legal Education Act and its regulations. Then there is when you become an advocate, 80% of the question will come from there. So the main things you need to know here is the Advocates Act and the Law Society of Professional Code of Conduct for Lawyers 2017. Professional Code of Conduct for Lawyers 2017. Then you need to know the Advocates Act, the various regulations which deals with the different issues, like Advocates Remuneration Order on the remuneration of advocates, marketing rules, which deals with 2014, which deal with advertisement of advocates, professional senior counsel rules, which deals with advocates, which are senior counsels, advocate practice rules, which deals with the practice of advocates, etc., etc. So like 80% of questions will come from here. Then 10% of the questions will come from when an advocate now become a judicial officer, is either become enters DPP office, enters public service. So you need to know some things to do with the judicial service, judicial code of conduct for judges 2020, code of conduct for prosecutors, public officers ethics act, county government act for advocates who act as county attorneys, etc, etc. So yeah, that is a very good introduction. And 3 out of 6 questions in the any exams are repeated. So it's good to look at the past papers sequentially. And that is the purpose of this exam, this recording. So you start with the Q&A, then you come to the recordings. Yeah, you make notes. So we now enter to April 2022 paper, which is on your screen. Hope you can see it.
Yes, I can see it.
So this was a recent paper, and I'm going to read question 1, which is usually compulsory. Yeah, you are newly admitted advocate working in a prestigious law firm, Pesamingi and Company. Bezeng hiring no musician as your employer on long-standing retainer. Bazeng has a long-time girlfriend Peng Ting has been making news for all the wrong reason. Bazeng was caught on camera assaulting Peng Zing. She filed charges against him and a warrant of arrest issued for his arrest. In an exam, every time, like for example, this is professional ethics and practice. So when you are reading a question in exams, you circle the ethical issues or practice issues that are likely to arise. So she filed charges against him and a warrant was issued for his arrest. But then was ignored the warrant severally and is reportedly going around saying he's untouchable. Peng Ting's advocates have made an application for contempt for court against Beijing. You have been assigned to handle Beijing matter. During the first meeting, Beijing instructs you to take all the necessary steps to ensure that the warrant is lifted and the matter never proceeds. There is one ethical issue now there. He wants the case delayed as long as possible because this is Kenya, in quotes. Another ethical issue, you circle that in if you are doing an exam. It also instruct you to use the firm social media accounts, Facebook and Twitter, to propagate the hashtag untouchable Beijing is new to judicial process. Another ethical issue, that one. This Beijing believes will increase popularity in social and improve the ease of his latest album. This take an interesting turn because Beijing validly terminates his retainer with Pesabing. He approached your employer, pleading with the firm to charge him lower than the scale provided under the remuneration order. Another fourth ethical issue. The firm agrees and enters into the fresh agreement with Beijing. Beijing has some knowledge of the law, having dropped out of school to pursue his music career. He was keen to pursue any other business or occupation, anything but law, he said. Although representing Bazeng would probably be the highlight of your career, your mind is not at ease. Discuss the following. Are you obliged to follow Bazeng instruction with regard to use your employer's social media accounts? Explain.
No, the straight answer is no.
Okay.
Yes.
So you give 4 points to answer 4 marks. Why are you saying it's no?
One, in I was reading the code of professional ethics, the SOPEC, where there was one of them was talking of an advocate upholding dignity of the profession. So it has talked about the use of social media. So unethical use of social media is actually prohibited by one of the principles I was reading there.
Yes.
That is one. Then can I remember the other one? Then there was also the image of the corporate image of the law firm, which is also at stake when they allow their the social media platform to be used for that particular purpose. And that can also lead to what is referred to as unethical conduct. That's another point. And well, those are the ones I can remember clearly.
So,
yes.
Answering, I want you to be very good in answering the question in exams.
Yes.
This is where the rubber meets the road.
Yes.
So the question is saying social media account and what is to use it to propagate the hashtag untouchable Bazeng is immune to judicial process. Uh-huh. So the straight answer is no. That is correct. But why are you saying no? You first of all, I want to project the code of conduct for lawyers.
Yes.
You can, in an exam, you can call it code of ethical code of practice and ethical conduct for advocates 2017. So point number one, and this is a point that you will repeat in almost all the exams questions.
Yes.
The overriding principles are very, very important.
Yes.
Values and principles of professional practice and ethical conduct. So number one is independence. So professional independence means that you are supposed to be free from influence of the client. Unaona?
Yes.
So when he's telling you to use the hashtag to do what is to do that, is you are not independent. Professional is key ingredient of professional ability to provide professional service to client objectively. Unaona?
Yes.
So point number two, this one you use them in every exams I can assure. Honesty and integrity. So honesty and integrity are the hallmark of the legal profession and must be executed by every legal professional dealing with client. So you know very well when you are saying that the hashtag is immune from judicial process, that you are not honest and you don't have integrity. Yeah?
Yes.
So that is point number two. Point number three, fidelity to the rule of law. So advocates want to be officers of court pursuant to section 55 of the Advocates Act. So first duty is the rule of law and due process. So he's officer of the court and must at all times indeed show fidelity to the rule of law. So when you are doing that hashtag, you are not doing to fidelity to the rule of law.
The rule of law.
Yeah, that is point number three. Those 3 points, you are going to use them in an exams. So another principle, overriding values and principle is also professionalism. So professionalism will go with honesty and integrity, will go together with independence, and will go together with fidelity of rule of law. Professionalism. The lawyer must demonstrate professionalism in his dealing with the client, with the fellow professionals, that party and judiciary. Professionalism requires that the law is competent and render service diligently and all times. So when you are doing that hashtag, that this client of yours is immune to judicial process, you are not professional. That is point number 4. Point number 5, you now go to the social media. So in a question that is specific to the social media, you go to point on social media. So social media, where is it found? It's found in 135, rule 135 to 139. So what does the rule that what does an advocate supposed to do as far as is concerned with social media? Number one, not inappropriately use social media. So particularly in a manner that undermines the standing and dignity of the legal profession and amount to professional misconduct. That is one. Uh-huh. So social media sites also, you should not use 138 concept to promote one's associate work. Therefore, that is on advertisement. So on social media, what is most relevant is 135. Inappropriate use of social media, particularly in a manner that undermines the standing and dignity of the legal professional, amount to professional misconduct. Are we together?
Yes, we are together.
Yeah, so those are 5 points I've given you. So B, with respect to Bazeng, let me share the question B. With respect to Bazeng, instruction that the case must never proceed, what are the ethical and legal considerations that you have to make before acting any further? 4 marks. So those are 4 points.
Yes, the first point I would talk about is the possibility of criminal liability if the advocate is knowingly participates in delaying the course of justice. The advocate is most likely to be held personally liable for professional misconduct. Yes. And another point would be what would I say? Basically that is what is clear, because the other one I think is related to it. The duty of the advocate to the court and administration of justice. I think they are related. Advocate being an officer of the court. Then there's also would there be a conflict of interest when the advocate wants to zealously represent his client, at the same time is an officer of the court who owes a duty to the court as an officer of the court to tell the court the truth?
So the duty to be an officer of the court,
Yes.
ranks higher than the duty to seriously represent
the client.
Yes. So
yes.
you must represent the client within the law.
Yes.
So, yeah. So this question, remember that this question is telling, this person, remember, has been charged with assaulting Pemthing. So he has already been charged. A warrant of arrest has been issued, but he does not want the court to the case to proceed.
To proceed, yes.
So the first point will be, this is a criminal criminal case. So
litigation. Yes.
Yeah. So
it's a criminal litigation case. Yes.
Yeah. So section 52 of the Constitution of Kenya, Fair Trial, section 52. E 52E says that every accused person has the right to fair trial, which includes the right to have the trial begin and conclude without unreasonable delay. So that is the first point. So you start by saying, when an advocate takes an oath of office,
yes,
when you take an oath to be admitted that the one you are going to take,
yes,
is usually sworn to defend the Constitution and to defend the rule of law. So the advocate will be going against his oath of office of defending the rule of law, and also is an officer of the court. Yes, which requires that a fair trial, court, public trials will start and end within reasonable time, according to Article 52E of the Constitution. So that is point number one. Point number two is that what you have said, that the advocate has a higher duty to assist the court to administer justice. As an officer of the court, more than delaying the case on behalf of the client. Another point is that the advocate will be infringing on the right of clients to have the case and started and concluded, because in any case he may be acquitted at the end of the day. So it is also in the client interest for the case to start and conclude within reasonable time.
Yes.
So also you talked about what we have talked in question A about honesty and integrity, fidelity to the rule of law, and professionalism. And you are going to earn your 4 marks. So this area of fidelity to the rule of law, honesty and integrity, professionalism, and the code of conduct is one area a student needs to read and understand very well, because you are going to use those areas in almost all the exams questions. Are we together?
Yes, we are together.
So next question. What are the ethical and legal effects of fresh agreements signed by Zeng and your employer? 6 marks. So you see, you give 6 points.
I think the first question would be on the validity of the agreement. Because the Advocates Remuneration Act, one of, I'm not very sure of the rules, but one of the rules prohibits advocates from charging fees below a certain threshold. Yes. Actually, undercut, they call it undercutting.
Yeah, that is point number 1.
Yes.
Another point.
And then the other thing is the effect of the illegality of that contract, because when a contract that actually abets an illegality is void from the beginning. Yes.
Point now, 2 points. Another one.
The other one is there's also the question of the advocate most likely to face a disciplinary action due to professional misconduct.
Yes.
For charging lower fees. Yes.
Yeah. So those are 3 points.
The other one. I think those are the ones I can remember as at now.
Very good. So, yeah. So number one, it is called undercutting, which is a professional misconduct. So, yeah. So the first section which is relevant is section 36(1). So any advocate who holds himself can project the Advocates Act. This is a very common question on undercutting. So if a question of on undercutting comes, you start in rank of priority, you start with the Advocate Act before even you go to the rules or code of conduct.
Yeah.
So you start
Yes,
with
yes.
the Advocate Act, you go to the regulation, then you go to the code of conduct. That is the order. So I want to share section 36 talks about undercutting. So this one a student needs to know if it is to answer this question in an exam. If you don't remember the section, just say Advocates Act. Yeah. So at section 36(1), any advocate who holds himself out to allows himself to be held out directly and directly, whether or not named as in prepared to do professional business at less than the remuneration paid under this shall be guilty of an offense. So it's a professional misconduct to charge lower fees. So section 36(2) is also relevant. No advocate shall charge or accept to otherwise than in payment of any fee or other condition in respect to professional the business which is less than the remuneration prescribed by the order under this act. So that is on undercutting. So after you talk about undercutting, you go now to section 46, which you have already talked about. 46D. What are valid agreements? 46D. Any agreement which an advocate agrees to accept in respect of professional business any fee other than consider which shall be less than the remuneration. So this kind of is illegal. So that one you have stated about. So the section is section 46D. So rule 3, advocates practice rules, also talks about I think I can project the rules. Practice rules are very, very important. They deal with the practice. So the advocate regulations, which are very, very important, they are there on their screen, is the Advocate Remuneration Order, 1962, Advocate Practice Rules, 1996, Advocate Disciplinary Rules, 1990, Advocates Complainant Commissions, which deals with the Advocate Commission, Advocates Professional Indemnity Regulation 2004, Senior Counsel Conferment Privilege 2011, Advocate Marketing and Advertisement Rules, and Advocate CPD Rules 2021. So practice rules. And they were made a long time ago. It was 1966. So, yeah. Rule 3, no advocate may hold himself out or allow himself to be heard at a directory and whether or not name being prepared to do professional business at less than, the scale that is advocate remuneration order. So practice rule prohibit. So those are like 3 points or 4. So rule 4, which you have talked about, advocate remuneration order, state that an advocate shall not agree to accept his remuneration as less than provided by this order. So that one you have talked about. Then you go to the code of conduct. Code of conduct, rule 62 to 64, talked about undercutting. And you can talk about, give some case laws. One famous case law is Ahmed Nasir versus National Bank. Another famous case is Jogu and Company Advocate versus National Bank. So this answer is found in year 2008 to 2019 Q&A, page 196, all the way to page 198. I've discussed everything to do on undercutting, a very common question in an exams. Are we together?
Yes, we are together.
So, yeah, so you need to internalize some those points. That is a question someone used to get all the 6 marks. In fact, it can come as a 10-mark question. Yeah, so you need to know a lot of things to do with it. It can come as a 10-mark question. Does the code of conduct, I'm now at question 1D, April 2022. Does the conduct of this Bazeng in this matter amount to contempt of court? Explain. 2 marks.
Yes, I think it does.
Mm-hmm.
The first point would be the defiance of court order, where the court order, the warrant of arrest is issued, and then he is ignoring it.
Mm-hmm.
That, I think, should amount to contempt of court.
Mm-hmm.
And then another one is trying to interfere with the judicial process when he instructs the advocate to delay the case. I think that also amounts to contempt of court because you are trying to manipulate the court process. Yes.
So, point number 1 of you is correct, but number 2 is not correct because remember the question here is telling us that the contempt of court is made against Bazings for saying he's not untouchable, for refusing to go to court. It's not on delaying the case,
Yes.
because the court does not know that he wants the case to be delayed. It's for not going to court.
Yes.
So so contempt of court also is given in criminal matters. Yeah. So failure to attend court without reasonable excuse can lead to serious include warrant of arrest. And failing to appear is contempt of court. So you also speak about penal code, section 121. An accused person who absent themselves from court after being notified of hearing may face additional charges. Contempt of court typically, refers to action that interfere with show respect and authority of dignity of the court. Yeah. Are we together?
Yes, we are together.
Yeah, so that is, you add that on that point on top of that.
Yes.
Yeah. So he explained to Bazeng any four characteristics of legal professional which would otherwise forbid you from handling this matter like any other charlatan in town.
I think I would go back to the principles that are guiding the conduct of an advocate. One of them would be what we talked about, the honesty and integrity. And the other one is the fidelity to the rule of law. I don't know whether I'm right when I think along that line.
Yeah, you
the
are
other
right.
one I would think of professionalism, the same characteristics we talked about there. And fidelity to the rule of law. Fidelity, which other? Honesty and integrity, fidelity to the rule of law. I think I can remember those ones.
Yeah, so that is correct. So you also include
Yes.
Legal professional is high. You start by saying that legal profession is highly regulated.
Yes.
You have qualification, academic and professional qualification.
Yes.
So you talk about KCSE, the minimum requirements, and then advocate training program. Then you say the regulation by Law Society of Kenya.
Yes.
Which regulate the practice of advocates. Unaona?
Yes.
Through issuing of you can talk about the Advocates Act, its regulations, Law Society of Kenya. Unaona?
Yes.
Then you can talk about if an advocate misbehave, he can be taken to Advocate Complainant Commission and disciplinary tribunal. Unaona?
Yes.
Then you can talk about court jurisdiction of advocates.
Yes.
Like someone can be, if an advocate has misbehaved, someone can sue him in court. Unaona?
Yes.
So you can talk also about what you have talked: honesty, integrity, fidelity to the rule of law, professionalism. Are we together?
Yes, we are together.
Yeah. So if a question comes about our legal professionals, legal profession is regulated, you talk about all those things.
Yes.
We got to the next question 2 of the day. Chief Justice Emeritus David K. Maraga once said, "The greatness of the nation lies in fidelity to the Constitution of Kenya, fidelity to the Constitution, adherence to the rule of law, and above all, respect to God." He said this when he nullified the 2017 presidential elections with other judges.
Yeah.
Assuming that you have assuming that you have chosen to practice law as a litigation counsel, when you complete the advocate training program, and that their key tenets of rule of law include legal certainty, avoidance of arbitrariness, and procedure and legal transparency. What contributes, if any? Question A, which is 6 marks. What contributes, if any? Will you be obliged to make the administration of justice as an officer of court in course of trial processes? What contribution, if any, will you be obliged to make to administration of justice as an officer of the court in course of trial processes? 6 marks.
Yes, the first point would be on the disclosure of information to the court. Yes, you have a duty to disclose any critical information, whether it is going to affect your client or not. Yes. And the other one is the duty to correct the court. Yes, where the court could be holding a particular position which is not the correct position and you are aware of it. It is your duty to correct the court. And then the third one would be putting court as a priority, being an officer of the court above the interest of your client. Yes, I think those are the contributions I would be making towards the administration of justice.
So yeah, so this is a very common question. It is also is like the same that as question 6 of November 2021, duty of an advocate to court. So yeah, so to add on the points that you have said, remember last time we said that you have a duty not to corruptly influence court.
Yes.
Yeah, that is another duty. Yeah. So another duty is to uphold rule of law. Remember, a court is guided by procedures. Yeah, you follow the procedural rules. Another point, very important, duty to maintain decorum and professionalism.
Yes.
So this is how you behave before court.
Yes.
Yeah. Then another duty to comply with court orders. Remember, during trial processes, a court may order this and this.
Yes.
An advocate must comply with the direction of the courts. Yeah. Another thing, remember some court proceedings are held in camera. So you have a duty to maintain confidentiality.
Yes.
Yeah, so that is on top of what you have said. A very common question on duties of an advocate to court. And last time I gave where that answer is found is in page 209 to 2011, yeah, 2008 to 2019 Q&A. A very common question also. 6 marks, but it's an easy one. This one, someone needs to get every 6 marks. Question 2B, how do you contribute to us increasing access to justice? 4 marks.
Immediately, I would look at it from the perspective of course. The first one is that I would not charge overly high fees so that many people can afford me, but definitely not below the minimum prescribed by the advocate's remuneration order. 2, I would also offer myself in certain cases pro bono services where the clients may not be able to afford, especially in criminal cases. Yes.
Good.
And
Those
yeah, yes, those are 2 points. And another one. No, the what I'm thinking of is not relevant. I don't think it would be relevant in this matter.
So, how do an advocate makes access to justice easy? Number one is pro bono, what you have said.
Yes.
So, number two, yeah. Number two is public legal education and awareness.
Okay, let me write. Oh, public legal education, eh?
Yeah, so you can advocate can access to by providing legal education awareness to public. You know, these like clinics that you are offered to communities.
Yes.
That is number two. Number three, point number three, public interest litigation. Like what Okia Mutata does. So you can do public interest litigation for public matters which are of high public interest. Those are 3 points.
Yes. What about what I talked about on the not charging overly high fees? Does it fit anywhere?
Yeah. I'm trying to fit to make it fit from where
and another point I was thinking about, promoting alternative dispute resolutions.
Very good.
So that things,
yeah,
things can be negotiated, not necessarily going for litigation.
So that point of view is not valid. The other one, ADR is what is valid. Advocate can encourage and facilitate ADR, such as mediation, arbitration, and negotiation. ADR mechanisms are more affordable, quicker, and less formal than traditional court proceedings. Yeah. Which can be beneficial to individuals who might otherwise be unable to avoid time or cost of litigation. Yeah.
Yes.
So number two, number nini. Yeah. So digital platform and innovations. In digital era, advocates can embrace technology to offer legal services for more wider. For example, advocates can provide online consultation, use social media to share legal information and work. Yeah. Another last point. Reduce delays in the judicial processes. Reducing delays in judicial processes.
Yes.
Advocates can contribute to reducing delays in judicial process by adhering to timelines, effective managing cases, and avoiding unnecessary adjournment. Justice delays, it is justice denied.
Yes.
Yeah, so those are the points.
Yes.
And you get your 4 marks. So we go to the next question. This question has not been tested. Question 4B, but is a question someone can think from the head and answer it.
Yes.
These are questions I which I usually call common sense questions. Yeah, you don't need to refer to the regulation any act. You just need to think. Like that question of advocate training program, how a young lawyer cannot be able, challenges of a young lawyer,
Yes.
and how you overcome it. November 2024, November 2021 question. So question 2 was good. Of course, question 1 was compulsory. You can't avoid it. So question 2 is a question I'll have someone could have chosen, and you could have gotten at half marks. Remember, you need just half marks to pass. So question 3.
Yes.
Question 3, question of the last question of the day. Advocate Mwamvili Mvumilivu have left his previous employers, Faster and Faster LP. He has now set up his own law firm. After advertising in the parameters provided in law, Mvumilivu finally lands his first client. Mvumilivu soon discovered that his client is challenging a sale agreement which Mvumilivu drew for a client which still at Faster and Faster LLP. The client still maintains a retainer with Faster and Faster LLP. After numerous correspondence with Faster and Faster LLP, it becomes clear that they will call your client as a witness in court in this matter. His client is unaware of this. They will call Mvumilivu. It's not your client. They call Mvumilivu as the witness in the court. His client is unaware of this and expects that this case will conclude expeditiously. Advocate Mvumilivu is still in very good terms with his previous employers and at Faster and Faster LLP. From your deep love and robust knowledge of professional ethics, advise what ethical issues Advocate Mvumilivu is facing in his current case and how best he should deal with the same.
The first ethical issue that I'm seeing here is the confidentiality and advocate-client privilege, which can very easily be breached in this matter, because somewhere in those in the advocate's code of conduct, it says that an advocate must not represent a client in a case where he's most likely to be called in to testify as a witness. Yeah, so there's a problem there with the confidentiality and the advocate-client privilege. And the basis is in the legal basis is in the Evidence Act section 134, which talks about the client's privilege. Yes. And then another issue I'm seeing here is the conflict of interest, where this client, they had served this client previously in their former firm, and now he has gone, he has come out. How do I put it? Is it a valid point, really? The conflict of interest here?
Yeah, it is a it is a valid of that is a valid question. Is a valid answer.
Yes, because this is the same person had represented the client the other side. So the kind of information he's holding puts it at crossroads with his current position. Yeah, given that he had worked in the other firm before.
Yes.
Yes.
So those are like 2 points.
Yes.
And this question is 4 marks.
So we need 2 more other points.
Yes. So this is a conflict of interest question.
Yes.
Because this person is representing a client
Yes.
Yeah. After he came out,
Yes.
sale agreement. He has a retainer. Yeah. So he is presenting a client against where he due when he was at Faster and Faster.
Yes.
So yeah, so you start by defining what a conflict of interest is.
Yes.
Yeah. So
I read it in, I think, section 60 of the Advocates Act. Is it? Which talks about
sorry?
a conduct that I think it is defined in section 60 of the Advocates Act. Yes, where I think they were talking about a conduct that put the legal profession as at a dishonorable. Is it that really? But I met, yes, but I met it somewhere. Yes.
So section 60
Yes.
is on hearing. Section 60
Yes.
is on complaint against an advocate.
Ah, okay, okay.
How a complaint is initiated.
Oh, okay. So you say we start by defining what conflict of interest is. Then which how do we move from after defining it? We highlight the circumstances which give rise to a conflict of interest.
So conflict of interest is defined in simple terms where interest of the client conflict with interest of another party.
Yes.
Where confidentiality will not be nini. Where an advocate will not zero defend nini.
Their client.
Yeah. So an advocate should not advise or represent both sides of a dispute.
Yes.
So a conflicting interest is an interest which gives rise to substantial risk that the advocate representation of the client will materially and adversely affected by advocate's own interests or by advocate duty to another current client, former client, or a third person. That is the definition.
Yes.
Is found in Rule 292 to 102 of the Code of Standard of Professional, the Code of Ethical Conduct. Code of Ethical Conduct 2017,
Yes.
Yeah, so after talking about that,
yes.
So and of course you have talked about this person recorded as a witness.
Yes.
Of course, the question is talking about that. So, Rule 8 of Advocate Practice, Rule 1966, what does it say? No advocate may appear such before any court or tribunal or any matter in which he has reason to be that may be required as a witness to give evidence, whether verbally or declaration. If while appearing in any matter it become apparent that he will be required as a witness to give evidence, whether verbally or declaration, he shall not continue to appear. Yeah. So you have answered the first bit of it. So how best should deal with the same? So the second bit of the question. So how when the conflict of interest arises, what does what does an advocate needs to do?
The first thing the advocate needs to do is to disclose to the client the circumstances and
Very good.
seek consent in writing from the client. So if the client still insists that of the representation, then that consent has to be given in writing to the advocate after the disclosure. That is one. Two, the advocate can withdraw from the case.
Yes.
Yes.
Very good. So those are 4 marks. Remember, a question you must answer or bit. Ethical issue
Yes.
and how best to deal with it. So those are 4 marks. Conflict of interest question is a very common question in exams. I've discussed it in substantially in year 2008 to 2019 Q&A, page 158, all the way to 150 to 163, including remedies of grant in case of conflict of interest, including case law. So it's good someone looks at that area. Yeah. So question B, under what ethical and legal justification is Mvumilivu permitted to advertise his new practice? 3 marks.
The first one would be to promote access to justice. Don't know whether I'm relevant. And I'm seeing it now. Under what ethical and legal justifications is Mvumilivu permitted to advertise his new practice? I think this is when you have a duty to promote access to justice, so that people need to know that you offer those services, but of course within the limits of advertisements, within the rules of advertisement, it's called marketing and advertisement.
Yes.
Yes, that is one area. I think that is what I can access to justice. I think that is what I can very comfortably discuss. Under what ethical and legal justifications is Mvumilivu permitted to advertise his new practice? Is there any other point other than just promoting access to justice?
Yes, that is point number 1. So I want us to look at the code of conduct.
Yes.
Let me project. Of course, point number 2, it says point number 2 is that an advocate is allowed to advertise pursuant to the regulations given by advertisement and marketing rules of 2014. That is second point. Point number 3, the code of conduct for code of conduct for ethical code for ethical conduct for advocates 2017 allows and I want to project it. So rule 31. Of course, when you're talking about access to justice, you talk as a fundamental rights and freedom under Article 48 of the Constitution, eh?
Yes.
Yeah. So that one, advertising and marketing. So Rule 2 of advocate practice rules, what does it say? So rationale for the standard, it's important that the persons requiring legal service able to access information about advocates qualified to offer that kind of services or person to seek. So section 34 is relevant. Scope of the standard. However, advocates should not solicit for work other means are compatible with the integrity, comply with the provision of advocate marketing and advertising rules. You have talked about that. Not detract with the integrity, independence, and dignity of legal professional, not to mislead and inform and vulnerable members of the public, not arouse unattainable hopes and expectations. Yeah, so that is some of the points, eh?
Yes.
Yeah. See, under what circumstances would advertisement by Mvumilivu be deemed unethical? 3 marks.
Under
Question
what
3C.
circumstances would advertising by Mvumilivu be deemed unethical? I think when you advertise outside of the advertising and marketing rules, because the advertising and marketing rules give even the manner in which you need to advertise. For example, when you decide to advertise in the media, when you promise what you're not able to deliver, it becomes unethical. And sometimes when you are doing the, for example, the signage, and then you go outside the dimensions which are prescribed there. Yes.
Yeah. So the marketing rules, eh?
Yes.
So that is point number 1, eh? Going against
the marketing and advertising rules.
Yeah, 2014, eh?
Yes, 2014.
So number 2 also is a code of conduct, what we have talked about, eh?
Yes.
A code of conduct where we have talked about, eh?
Yes.
Touting. advertisement that touting. In fact, it's talked about is in the Advocates Act, touting.
Yes.
What does advocates say about touting? So any unqualified person who in consideration of any payment or other advantage to himself, any person procures or attempts to procure the employment of an advocate such in any suit assets from an advocate, any such payment advertisement in consideration of employment shall deemed to be a tout. That is section 38.
Yes.
Touting.
Okay, when an advocate touts. Okay, yes.
Then not to arouse unattainable hopes and expectations. Remember the question?
Yes.
What are the circumstances would advertisement by Mvumilivu be deemed to be unethical? So when it is in the code of conduct,
Yes.
not to arouse unattainable hopes and expectation,
Yes.
Yeah. And you get your 3 marks. We are together?
Yes, we are together, but I think I'll really have to go back and look at this paper again.
Yes.
Yeah, because the questions inside here are a bit tricky.
Yes.
It looks simple, and when you start looking for points, you only get a quarter of the points or a third of them.
Yes.
Yes.